in a match between India and Australia, in a cricket match, can Australia bring along their own umpire to do the umpiring in the match? This is that is the question that we're going to be talking about today. Whether, there's a big company, a small company, the big company says, if there is a dispute between us and there's a contract that is being entered into by both parties, the big company says, if there is a dispute between us, then I, the big company, will be able to appoint an arbitrator, and you, the small company, will not have any say in it. Is that legal in India? My name is Ramana Reddy and I'm a practicing lawyer at the High Court of Telangana. And I help you by simplifying legal concepts. If you would like weekly tips, tricks, and general legal content, hit the subscribe button below. So what is the problem? The problem, like I said, is if in a match between India and Australia, can Australia bring their umpire along? While this may seem very obvious, I'll tell you why it is not. Because the bedrock of arbitration is consent between the parties. So the idea is both these parties have entered into an agreement, and the parties have said that Australia can bring along their own umpire, or the big company can nominate their own arbitrator, and the small company will have no say in it. And the small company agreed to it. It signed the document with its eyes wide open. So party autonomy is a big principle behind arbitration. So when we are faced with such a situation, should courts interfere and say that in such a situation, this is not fair, this arbitrator may be biased, and therefore, that this clause is illegal. Now, for a long time, the Supreme Court upheld, or the Indian Supreme Court upheld the autonomy of the parties and said that, nothing doing, small company, you signed this clause with your eyes wide open. So therefore, you are just bound by the agreement, and the big company will pick the arbitrator. Now, until a case called Perkins-Eastman. Now, in that particular case, what happened was the arbitration clause said that the managing director or his appointee will have the right to appoint a sole arbitrator. So there's one arbitrator, one company will be able to appoint, the other company has no right to say, has no right whatsoever, has no say. Now, in that case, the Supreme Court, went in detail and it examined whether, whether party autonomy should be allowed to the extent where, a person can be a judge in his own cause. If Australia can bring their umpire along, then there is bound to be some bias in the adjudication process. So in that case, the Supreme Court said that while party autonomy is something that we understand and something that we uphold in India, but we cannot allow unilateral appointment of a sole arbitrator, or unilateral appointment where one party, suppose the arbitration clause provide for 3 arbitrators and one party can appoint 2 arbitrators, and even that is bias. The Supreme Court said that will not be legal in India anymore. If there is such a clause where one party can appoint a sole arbitrator or a majority of the arbitrators, then you can just go to the High Court under Section 11 of the Arbitration Act and ask the High Court to do the appointing for you. But there is one exception to this rule. Generally, this happens when you're dealing with the government, say you're dealing with the railways, you're dealing with some other government body that floats, say, tenders from time to time. And since these organizations are effectively monopolies in their own field, immune from competition, sadly, they get to dictate terms. So they may say that that the arbitrator will be nominated by us. That is illegal, except if they say that the arbitrator can be picked by from a panel of arbitrators that we maintain, and there is enough variety in the panel. So if all of them are just ex-employees of that particular government entity, then more likely or not they're going to be biased. But on the other hand, if that panel also consists of, say, ex high court judges, or not, or employees of different government departments, or engineers and people who generally have good subject matter expertise over those kind of tenders, for example, then in those kinds of cases, the court will uphold that clause, because there is less likelihood of bias, because the pool is just too big, so, and there's enough variety there, so that you can pick an arbitrator from there. Personally, I disagree with that view, because no person should be allowed to be a judge in their own cause, regardless of the variety or the number of people. But hey, I'm not the Supreme Court. That is the law of the land. So that is the so that is a position. To summarize, there cannot be unilateral appointment of an arbitrator. Australia cannot bring along their own empire for a cricket match against India, subject to one exception, which is, if Australia has many empires that they pick from, and the empire does not belong to Australia but belongs to, say, Bangladesh and so and so, and so many, and there's a pool of empires that is maintained belonging to different countries, then in that particular case, probably the appointment of the empire will be upheld. Similarly, in a contract case where there's an arbitration clause and one party has the unilateral right to appoint an arbitrator, if the panel from which the arbitrator will be chosen is there's a lot of people there, a lot of variety there, then in that case the court may most likely uphold the appointment of the arbitrator. I hope that was helpful. For weekly tips, tricks and general legal advice, hit the subscribe button below. Thank you for watching.